Welcome back, everyone. This chapter introduces the foundational topics of privacy in the workplace and beyond. Technological advancement complicates traditional notions of privacy, ranging from surveillance cameras and key logging to genetic data and social media activity. Where do you feel the line should be drawn between employer interest and personal freedom? As we navigate through this digital labyrinth together, remember, your smartphone knows more about your daily habits than your spouse does, and it's selling that information to the highest bidder. In today's digital age, privacy concerns have become increasingly complex as technology advances. From workplace surveillance to genetic information protection, the boundaries between personal and professional lives continue to blur. This lecture will explore the ethical and legal dimensions of privacy in business environments. We'll also look at how courts interpret privacy laws, how employers monitor employees, and how technology companies handle user data. We'll also discuss the implications of social media on privacy and the protection of genetic information. Some key concepts we'll cover in this chapter: workplace surveillance, aka your boss is watching, the value of privacy, that thing we all claim we want but give away for free apps, lifestyle control and off-duty conduct, social media and privacy, the ultimate paradox, right? Genetic information, algorithmic decision making, smart devices, and privacy concerns. I want to talk about workplace surveillance. We could actually call this chapter "The Digital Boss is Watching." In this case study listed here, Elling versus Monmouth Ocean Hospital Service Corp., a nurse made Facebook posts visible only to her friends. The plot twist here was her friend shared posts with the supervisor. And the court ruled that no privacy was violated when posts were voluntarily shared by an authorized viewer. More recently, there's remote work monitoring controversy. Glassdoor says that remote monitoring references are up 216% in the last 4 years. The pandemic era shift to remote work created a lasting ecosystem of employee monitoring software. Last year, a major consulting firm faced backlash after implementing software that took random screenshots of employee screens and used AI to calculate productivity scores. Several employees discovered their private medical information was captured in these screenshots and shared with managers. The resulting lawsuit highlighted the need for clear boundaries in digital surveillance. Now, in this week, I've included supplemental reading on this topic called Workplace Surveillance and Remote Work. This article talks about, as the global COVID-19 pandemic swept across the world, digital technologies played a critical role in connecting employers with employees beyond the physical workspace and into employees' homes. Not only have such advancements in technology allowed employees to work remotely, but they've also enabled employers to track, monitor, and analyze workers in new and innovative ways. Emerging technologies provide employers with new forms of data about the workers, and as a consequence, new opportunities for worker surveillance, management, and even the performance evaluations. As of 2016, more than a quarter of employers have found content online that has led to the reprimand or firing of an employee. So here's some food for thought. Just because you can monitor employees doesn't mean you should. The trust you build by respecting privacy often outweighs what you learn through surveillance. Now, there are some core values of privacy. The first is personal autonomy, the freedom to be yourself without judgment. Emotional release, space to express your feelings privately. Self-evaluation, room to reflect on thoughts and actions. Limited communication, control over who knows what about you. There's a modern movement called the digital detox movement, the right to disconnect movement, as it's also called. And this has gained significant traction with several states passing laws that prohibit employers from contacting employees during designated off hours, except in genuine emergencies. This represents a recognition that constant connectivity has eroded essential privacy boundaries between work and personal life. Think about it. Privacy isn't about having something to hide, it's about having something to protect, your sense of self. The Smith versus Pillsbury case raises important ethical questions about privacy in a workplace communications. From a utilitarian perspective, while Pillsbury may benefit from monitoring emails to identify problematic employees, this must be balanced against potential harm to morale and trust. From a deontological standpoint, both the employee's right to privacy and the company's right to control its property must be considered. The Hulk Hogan case against Gawker involved personal autonomy and intrusion upon seclusion. And that case eventually settled for $31 million, resulting in Gawker's websites being shut down. Lifestyle control. In other words, what you do after 5 p.m. Now, in this case, New York versus Walmart, the case centered on whether dating falls under legal recreational activity protected by New York law. The court gave a narrow interpretation, ruling that dating was not included in protected activities. The case highlights the tension between employer control and employee freedom in off-duty activities. In this case, the court ruled dating a coworker wasn't legal recreational activity protected under New York law, and it narrowly interpreted employee protection laws. Now, state laws vary widely in how they protect employees' off-duty conduct. Some states specifically protect tobacco use, while others have broader protections for legal recreational activities or constitutional privacy rights. So, some policy considerations. Employer interest. Control health benefit costs, set standards, protect brand. Health benefit costs related to employee lifestyle choices, employee rights to privacy outside of work, work-life balance concerns, and state laws vary widely in protection of that off-duty conduct. Here's another example, the fitness tracker dilemma. Several major insurance companies now offer premium discounts for employees who share their fitness tracker data. Last month, an employee filed a discrimination claim after being denied health benefits due to declining to share his sleep data. The case has reignited debates about whether companies should have access to health behaviors occurring outside work hours. The debate about how much an employer should care and should control what an employee does off the job is an interesting debate. Later in this discussion, we'll talk about this on social networking. This section could easily be tied in to that section as employers are increasingly using social networking sites to screen potential employees and to monitor their current employees. The ACLU published an article titled Introduction to Lifestyle Discrimination in the Workplace. And this article discussed discrimination in the workplace and provided information regarding state and federal laws. Most of the states listed has provided some sort of protection to address the right to smoke. Now, Facebook launched a Beacon program to track user purchases and share them with friends without explicit consent. This resulted in a class action suit in the Lane versus Facebook case. In the Lane versus Facebook case. And the settlement, which led to the creation of the Digital Trust Foundation. So Facebook agreed to terminate Beacon and fund the Digital Trust Foundation. But there was a little bit of controversy in this case. The dissenting judge questioned why class members received no compensation while Facebook controlled the foundation. While we're on this topic, I want to talk about super cookies. These are codes that track users' web activity and report it. For example, Verizon's been criticized for its super cookies, which are difficult to delete and report Verizon subscribers' web activity to Verizon, which it can then share with third parties. Telematic surveillance can be implemented via a variety of devices that are connected to various networks, including phones, cars, computers, etc. Companies use this information to gather a wide variety of data on consumer habits. Going back to Facebook, today's Facebook business model still relies on tracking user activity across platforms, though with a little more voluntary participation through Facebook Connect. Companies continue to use super cookies and telematic surveillance to track consumer behavior online. Then there is the TikTok truth algorithm controversy. TikTok created an algorithm update promising to show users content that challenges your worldview, but requires scanning message history across multiple platforms to determine your political learnings. Many praise the attempt to bust filter bubbles. Privacy advocates have filed complaints arguing that the feature goes beyond reasonable data collection practices. So, as a reality check, think about this. We spend hours customizing our privacy settings, then voluntarily post our location, meals, and innermost thoughts for the world to see. We are indeed complicated creatures. Some things to think about with social media and ethics. Is there an ethical duty to protect privacy, considering the great privacy giveaway era that we're in? Also, ethical frameworks, deontology, utilitarianism, virtue ethics perspectives, which we talked about in previous chapters. And also technology solutions, default privacy settings, opt-in versus opt-out approaches. And personal responsibility, individual choices to protect one's own privacy. Companies like Facebook and Google could make privacy protection easier by changing the default settings to prioritize privacy rather than requiring users to opt in to privacy features. Similarly, government could require privacy protect defaults through legislation. Now let's talk a little bit about genetic information privacy. We could also call this your DNA is not your resume. And so in this, we have what are called GINA protections, Genetic Information Non-Discrimination Act. This came about in 2008. It prohibits employers from requesting genetic information. It limits how genetic data can be used in employment decisions. In the Fabricant case that is discussed in your textbook, the company violated GINA by asking family for medical history during a post-offer medical examination. And this resulted in an EEOC settlement. As genetic testing becomes more common, balancing scientific advancement with privacy protection remains challenging. More recently, we have the DIY genetic testing workplace issue. A startup recently faced legal challenges after requiring employees to submit results from consumer genetic tests as part of the Wellness Initiative. Although the company claimed this would help personalize health recommendations, the EEOC found that tying performance reviews to participation violated GINA. And the company settled for $3.2 million in damages. Here's something worth considering. Your genetic code may determine your eye color, but should it determine your employability? GINA says absolutely not. Here are a few scenarios to explain GINA violations to help understand it better. And I won't read through all of these, but just as some examples. If the scenario is family cancer, history of family cancer, it is considered a GINA violation because the supervisor improperly accessed genetic information from a wellness program. However, medical leave documentation is not a GINA violation because the employer requested verification of medical condition, not genetic information. Another example might be any other kind of mandated testing could be a GINA violation because legal acquisition but improper use of the information to demote an employee is considered a violation. The Human Genomes Project actually published participants' names. That's not technically violating GINA since researchers are not employers or insurance companies. But better privacy protections might include limiting identifying information and requiring data access agreements with penalties for violations. I mentioned earlier about the great privacy giveaway. Now, this has significant downsides as we all individuals sacrifice our privacy for convenience. From the deontological perspective, we have that duty to protect our dignity by safeguarding that information. Utilitarians would argue that considering long-term consequences of oversharing prevents harm, as demonstrated in Congressman Weiner's career-ending disclosures. Technology companies could make privacy protection easier by changing defaults to privacy settings, like I mentioned earlier, to opt out rather than opt in. The ethical analysis of Facebook users' endorsement practices raises some important questions about informed consent, the meaning of user actions on the platform, and the responsibility of the social media companies to their users. Some considerations would be user endorsements. Questions about whether that consent in user agreements is truly voluntary when the terms are buried in complex documents. I mean, how many of us actually read and scroll through all of that fine print before we check that box? Ethical perspectives. Free market ethics might support Facebook's profit seeking within legal bounds. Deontologists might question whether executives would want to be bound by such hidden terms. And ethics of care raises concerns about respecting the user relationships. Then we also have the like button complexity. Users might like content for various reasons beyond genuine endorsement. Facebook now offers more reaction options with varied meanings. And also legal challenges. Angela Fraley's lawsuit against Facebook for sponsored stories resulted in a class action settlement. Now, the San Bernardino shooting case highlighted tensions between Apple and the FBI over privacy and security. This debate reflects broader questions about the balance between individual privacy rights and public safety concerns. So on this slide, we're talking about privacy and security. Whether it's national security, government agents need access to information to prevent national threats, terrorism, criminal investigations, public safety concerns. That's how the whole TSA concept came about. Also, international approaches, different legal frameworks worldwide. England and Germany have content removal laws, and also varying approaches to data retention. Privacy protection, companies and individuals value data security, that personal information protection, business confidentiality, trust in technology. And then finally, privacy and security from the ethical perspective. Different frameworks would yield different conclusions. Utilitarians might favor helping FBI to save lives, while deontologists struggle with principles of life versus privacy. Algorithms and hiring. We could look at this from the perspective of when robots become recruiters. And we're really looking here at the AI hiring landscape. 25% of companies use AI for initial resume screening, that keyword search. 75% report reduction in hiring time. And 40% of HR professionals worry about algorithmic bias. The ethical implications about the algorithmic hiring practices are significant. Some argue that algorithms remove human biases from hiring, and research suggests that hiring algorithms are not neutral. As noted in the Harvard Business Review, these systems can perpetuate existing biases in hiring data. Additionally, as applicants learn to game the system to get better scores and more job offers, this raises concerns about whether the algorithms are truly identifying the best candidates or simply those who have learned to optimize their applications for algorithmic screening. Key insight here is that an algorithm is only as unbiased as the data it's fed. If your historical hiring practices were biased, your AI will be too, just more efficiently. I want to briefly talk about the Ashley Madison hack. This happened in 2015. And so this website encouraged extramarital affairs, and the breach exposed users, leading to divorces, resignations, and even suicides. The legal fallout? Over $500 million in lawsuits were filed. Users had to out themselves to join the class action suit. And so from an ethical standpoint, the utilitarian, privacy breach caused mass harm versus sight, moral ambiguity. Deontology, the user's right to privacy was still violated. Should people using unethical services still be protected by privacy laws? Here's a modern parallel to that. OnlyFans had a leak of creators' personal data in 2023. Let's talk about smart devices, the ears in your living room. They're always on. Listening devices raise privacy concerns. Companies gather data to improve products and target marketing. And questions about law enforcement access to recordings. When we approach this concept from several different perspectives, we could talk about business motivations. Amazon and other companies gather data through Alexa and Echo and similar devices. Devices to better understand consumer behavior, improve products, and target marketing efforts. But there are privacy concerns. They're always on, listening, and that raises questions about what is actually being collected. How is it being used, and who accesses that? If you're having a private conversation in your living room, how are they using that for business? When we talk about consumer benefits, convenience, personalization, and access to services through voice commands provide significant value to users. You can easily say, "Hey Alexa, please order more toilet paper," and then it arrives at your door. So there are certainly conveniences associated with that. Now, law enforcement access raises questions about whether law enforcement should have access to this data in criminal investigations, and that creates tension between public safety and privacy rights. In a landmark case a couple of years ago, the trial of Timothy Verrill in New Hampshire for a double murder. There was a murder conviction was secured for him partially based on ambient recordings from a smart speaker that captured incriminating statements. While the court permitted the evidence, it sparked renewed debate about expectations of privacy in homes filled with internet-connected devices. So let's talk about privacy and employment. We have what's called the ban the box movement, and that's second chances in employment. This removes criminal history questions from initial job applications. It delays background checks until later in the hiring process. And it's been adopted by over 150 cities in 29 states as of 2023. Now, in 2025, that has expanded to 35 states. But we have what's called a reintegration success story. A national retail chain implemented comprehensive second chance hiring program that not only removed criminal history questions from applications, but also created specific training programs for formerly incarcerated individuals. Their data showed these employees had higher retention rates and stronger company loyalty than the general workforce, challenging assumptions about hiring risk. Some companies that are using this second chance program include Walmart, Giant Food, Goodwill Industries, companies like that. Sometimes the most qualified candidate is the one who has made mistakes and learned from them. And so the ban the box movement gives them a chance to prove it. The National Work Rights Institute has been working to address the challenges faced by individuals with criminal records in the employment context. You can learn and review information about this institute and see their most recent initiatives on workrights.us. This is a very great website and has valuable information on it. Some final thoughts. As technology continues advancing at breakneck speed, the line between helpful innovation and harmful intrusion grows increasingly blurry. The most important privacy question isn't technological, it's ethical. Just because we can collect data, should we? And if we do, what responsibilities come with it? Remember, in a world where your refrigerator can tweet what you ate for breakfast, protecting privacy requires vigilance, values, and a willingness to occasionally unplug. The greatest privacy setting ever intended is still the off button.